22, Annexes 6 are set aside. We have issued direction to the superintending engineer to consider the representation.
Yes, I agree.
For judgment, item number 2, WPC 37718 of 2023.
In view of the facts as discussed above, we do not find any justification in the action of the authorities imposing the penalty and demanding the recovery thereof from the different contracts. Same is hereby quashed and exercised. The authorities are directed to release the retention money within 6 weeks from the date of the communication of this order. It's called.
Misbehave the Asaka Mage and he has admitted that, but pending finalization this present tender, we have allowed him to work. That's the allegation. And he has admitted in the last petition has admitted.
Where? I could not get it. What is this?
Limited company.
My lord?
Petitioner is a private limited company.
Yes, my lord.
That company, how can it abuse or misbehave?
His staff were in charge of the implementing. That is he admitted last page in Odia, you lordship may kindly see. He has admitted.
We don't have copies of it. Just a minute.
A finalization tender, we have allowed him to supply.
Oh. I say so and so. Staff of this company. Supplies also. Which is taken as offensive. He admits one of the staff of that company.
In view of that allegation, previously he was doing the work. For one extension he was also giving. This time, pending inquiry of this matter, he has been given extension till final tender, present tender.
But this, the contract was for a period of
1 year, my lord.
1 year there.
so 1 year has expired.
Expired.
You have floated a fresh tender.
Hello?
You have floated a fresh tender.
Proceeded with the tender.
Fresh tender you have floated.
Floated. 126 we have floated.
Correct.
Pending finalization, we have allowed him to supply.
What is that?
1 year plus 1. This is 1 year plus 1 year. If my performance is satisfactory, that is at running pace 37. Period of engagement 1 year, and the engagement shall be for a period of 1 year from the signing of contract. That is with effect from 1/1/25 to 31/12/25. It will be extended for another year after satisfactory performance as per DUSS.
So with effect from 1/1/2025, the contract ceases.
See,
Lapse.
my lord, as per this
26.
clause, if my performance, it is a contingent clause.
126.
31, 31, 12.
That is the last day.
1126.
It's not longer there.
My lord, if it was a simple contract from 1/1/25 to 31/12/25, my lord, I have no case. It is contingent on the fact.
Mr. Counsel, there are two concepts.
Ma'am.
One is an absolute right to have the extension, and one is a right which is there but dependent upon a certain contingencies.
Exactly.
Now, according to you, the contingencies are in your favor.
Yes.
Correct. Now, it is a subjective satisfaction of the person whether such contingencies are favoring you or not favoring you.
My lord.
So if they have found, maybe somebody has said excellent, good, very good, but they in their own subjective satisfaction did not find. One instance, two instances, whatever be, it is within their domain to do it. Once they have decided,
It has to
once
be
they have decided to float,
rationality, my lords. It's just not,
nationality is a,
it's like giving a
No.
dog a bad name and throwing it
No.
out, my lords.
it's not a throwing, it's a fresh.
This, what's is representation which is given?
That is also not.
Just.
Yes.
Now, have you considered his
We have
representation?
said that we will till this final. We have said that till this tender is final, you have to work only.
No,
Not beyond that.
to that effect. My lords, what my learned senior is saying is on the basis of instructions he has received, he's saying.
No, in letters they have
No
written that.
communication clause.
Within the exclusive. So the law on this subject is very, very clear.
Yes.
It is within the administrative's domain to judge or to assess the performance. You are showing a document before us. We cannot substitute ourselves into the armchair of the administrative authorities and take an administrative decision all the time. It is the running of the administration lies with them. So let them run. It is their subjective satisfaction. If they have decided to float a contract, the tender, you can't stand in the way.
No, my lords, my.
You are banking upon certain documents which is there. You are saying that, look, my performance is this, my performance is that, my performance is above board, my performance is beyond any conceivable lapses. What is this? Can we go into this? Show us the judgment.
No, my.
We can't substitute ourselves. The court will run the administration all the time. We will simply see the process by which the decision has been taken is a faulty. We are not going into the nuances or the nitty-gritty of the decision taken by the authority in the administrative side. I think the law is very well settled now as this time. We can't enter into this. This is where their domain, they have said, since this is a very, very important and significant services, because a disruption even for a half day will cause a lot of inconvenience. So they have decided to extend till the finalization of the fresh tender. You can't participate in the fresh tender. There cannot be any kind of the blots or a stigma to be put because they have not taken that decision. You participate there.
My lords, may I pray, my lords, there are judgments of the apex court, my lords, where they say if the conclusion arrived at is arbitrary or without any basis, Contrary to the documents of record.
Again, there is no consideration or a decision. Floating of a tender is an arbitrary one.
My lords,
You're talking about you really wanted to forest on. It will not. It says will be extended for another period of 1 year, subject to the satisfactory performance. So if they have floated a tender, we are not going to interfere in it. That's my view, subject to my brother agreeing with me. But it's not an automatic vested or accrued right in that sense.
My lord, I have a legitimate expectation if I perform well by.
It's a legitimate expectation if it is brindled with certain conditions.
Yes, my lord. It is.
And this is a contingencies which is there. Show us that the contingencies, the court will lift those contingencies. It is a contingent one. It is not an absolute one.
I get your lordship's point. Let it come up tomorrow, my lord. I'll show the judgments on the point.
Show us.
Yes, my lord.
And the series of judgments is the court will not look into the decision,
My lord.
but only the process by which the decision has been arrived.
My lord.
And on the basis of a Wednesbury's principles, nothing more than that.
My lord. Let it come up
We will not.
tomorrow, my lord. Oblige.
We give you a fullest opportunity to do it.
That
No difficulty.
that I cannot have any comment on. Tomorrow, my lords, I'll show your lordships.
Please,
For your lordships.
that is what is troubling me.
Yeah, I know. I get your lordship's point.
Yes.
Whether your lordships can go into their my lord subjective satisfaction over the matter, I will try to satisfy your lord. Oblige. Let it be the first item tomorrow.
Will be.
If I go, my lords, I'm out of court.
Yes.
Your lordships are convinced.
When is the last date for submission of the
Today.
today?
Today is the opening, my lords. Tomorrow,
You have not participated.
I'll take it. Oblige.
The body language of the junior shows that you have participated. Yes, next.
Item 4.
Lots of large copies of lots of large copies. Lots of large copies on Monday. I was directed whether DRC 07 has been issued or not. We have already corrected the order in original by rectifying the order on 28/1/2026. But DRC 07 could not be corrected, and we have raised a token before the council, and still it is pending, and we are trying our level best.
This relates to the
They have already rectified the orders
land.
and they are contemplating to rectify the DRC 7 as well.
Unless that is rectified, Your Lordship, I cannot find the.
No, if not, then we will see. If he is submitting something
Yes.
and he has already carried out some, the desired rectification, as you pointed out, in the original. Let us see what.
Because your right will arise or approve of 85 the DRC 7. So they have said that they have already raised the token so that the portal will be open for them to upload that rectification or whatever that has been done in the order is not even. Then you will be able to know that what they have done. And then your right will definitely.
And to file appeal has not lapsed till that, so you have the time.
Let this writ be pending, Your Lordship. That's all. Your Lordship, APL 0.
Admitted, he has allowed.
And he says that I have already rectified. Maybe not exactly in the tune as you want it, but he says rectification. If you have agreed you will have the another second opportunity to challenge that rectified order.
APL 04 still reflects the same thing. He's
But even in a, that is what he says, that we have already raised the token so that the portal will be made open and accessible to them. They will make necessary corrections in the order business by virtue of that rectified order. And this will, again, they will upload a DRC system. This is what the will do.
Against that DRC 7, Your Lordship, I preferred appeal. Now,
Now that appeal is also becoming an infructuous because of this subsequent act 28-1.
but unless
28-1. So unless that is rectified in DRC 7, I know that your right has not ripened for an appeal. So that is what they are admitting. That we can't straight away go and access. A token is generated so that the system, the portal who is managing the portal, will definitely make them accessible so that they can rectify that orders. So that rectified order will be a fresh order for the purpose of appeal.
You will observe that you intend to fight.
Sir, madam, in a civil concept, I always go by a civil concept. Decree is passed and the appeal is filed. Decree is rectified. It gives you a fresh cause of action or a period of limitation for an appeal from the date of a rectification, not from the date of the passing of the law.
unless Your Lordship watches this APL
We are simply recording what he has said, that we have already undertaken an exercise of rectification. Rectification has been done. Only thing is that those have to be reflected in the DRC 7. Since they do not have the direct access, they have already raised the token. Moment the access will come, they will put what the rectified orders are and will be made available to you. And there from limitation will start ticking. The very simple way. It's a fresh lease of right to you, madam.
But unless this APL 04
If
is quashed,
your data appeal is time barred, you are saved. That's a,
Lordship,
I would say, it's a blessing in disguise that has come.
And Your Lordship have to file 2 appeals.
No, madam, that is what it charges. Once the order is rectified, then the original order evaporates or merges with the rectified order.
Already, Your Lordship, original order against that I preferred appeal. Now against that appeal and before Your Lordship.
Now, you have to file appeal for the Ministry Appellate Tribunal.
Yes, Your Lordship.
So you take this order, rectified order,
Yes, Your Lordship.
so you have challenged the appellate order.
Yes, Your Lordship.
You file 161 petition before the appellate authority. Taking this, he will amend that. Both the orders you carry it to the second appellate tribunal.
Yesterday I tried doing that, Your Lordship, but in that APL that is available in the portal that says that already 3 months have passed, so 161 cannot be done. Like Your Lordship is suggesting, suppose I am doing that 161 against that order, that DRC 7 when it comes rectified.
Appeal order, have you tried appeal order to be rectified?
Yes, Your Lordship. I have this screenshot with me that says that the 3 months.
Order is original has already been rectified. So that will impact the appellate authority order as well. Please consider that.
How will that be taken on, Your Lordship?
Have you read this paragraph 3?
Yes, Your Lordship. That did not even need it. That did not even.
Observation of this court as reflected here,
Yes,
and
Your Lordship.
rectification was carried.
Yes, Your Lordship. Now how?
And that too,
My problem is, Your Lordship, now the appeal stands disposed of, Your Lordship. Everything that I need to do needs to be done on the portal. The portal, I yesterday rectification action that says that already 3 months have passed, you cannot do that. So if it rejects my application, again I have to approach Your Lordship. All I'm
I
doing,
don't
Your
know
Lordship,
the best available for have to get the appellate order rectified in tune with this.
Lordship, may I see this pop-up that
Your
comes?
Lordship, in this order has been passed on 21/1/2026. I have to just verify whether they can challenge this order and that. I have to just verify and inquire with the department. Because in this order, they have written that you can file an appeal against before the as and a first appellate authority in this order. So I have to just verify.
Yes, you still need to negotiation. Yes. You have the feedback. You impress upon the this. Taking into account this and this both the appellate authority will also rectify so because of this, because similar to it, shall forward this thing to the appellate authority, so that he will take
This has been already uploaded.
we are posting it.
I'll try my level best to get it corrected.
Solve it.
Resolve the
In common practice is very enforceable.
Probably also I have to verify whether that order will prevail or this order will end.
No.
You cannot have to take this. You cannot write remedies.
This in this also you can written you can file an appeal in this order.
No. Why should? One appeal is already there. Rejecting.
Right.
So what will happen to that? Your appellate authority has also to rectify his own order. The special case you think of.
Okay.
Madam.
Obliged.
Three. Change.
Yes.
Good. Good job. Item number 1, weekly list, WPC 9272 of 2018.
Well, that's. Item number 1 has been specifically assigned to learner ATS Ashra Das. He's been suffering from high fever since last night. So he is undisputed in this news. I was just thinking on Friday or
You don't have the call.
If you also can see the notice could be stored without the program. Let silent of notice is to be issued, not issued.
Have you deposited the requisite 14 out of 10 we accept? The office is directed to immediately take steps for issues. The service.
Personal fee is not paid.
Paid.
Not affecting the service as directed as here.
Well, in this matter, in fact, one fact is not brought into record here.
Notice is for a fact brought. Is it the argument? Hearing.
No, only I am pressing the fact. The relief for which the petitioner has filed the writ petition, before filing writ petition, the petitioner has approached the civil court.
Keep it reserved, brother, at the time of hearing.
Indicate that in your affidavit, sir. File it.
Yes.
The suppression of a material fact, we know. File it.
Item number 6. Item 6.
Make previous launch. Lots.
Because the move question, before your lordship to consider is whether once the tender has been revoked, can the financial bids of the participants be opened within 24 hours of this bidding given? That's the simple question. But here I would like to apprise your lordship for.
The tender has already been cancelled.
Yes.
Cancellation order precedes the opening of the financial bid.
Yes.
Or posterior to a financial bid.
Not one, two cancellation orders, one on administrative grounds, one on technical grounds, both precede the order of opening of the financial bids. So if your lordship.
How can it be?
No.
It's simple thing.
No.
If this is correct, have you cancelled this tender?
No, that is not the time.
That's not. Okay.
So now I narrate the facts, my lords.
Now towards the document that they have considered.
Yes.
To us.
Mobilized movements. Lordship may kindly come to Annexure 9, page 78.
Listen.
9, page 78.
Yes.
Lordship may kindly see. It is informed, and this is dated 13th October. It is informed that due to administrative reasons, the above tender has been revoked from technical evaluation to technical bid. This is a document which they don't dispute. And the matter does not end there. Lordship may kindly see the next annexure. By that, it was to inform you, that is me, that your bid dated so-and-so has been opened and updated summary by the duly constituted committee. Your bid has been admitted.
Okay, tell me, this is the first letter at 78 is
Annexure 9.
This was 13th October.
13th October.
Correct. And this is the same day.
Same day.
13th October. Uploading time is Yes, subsequent.
Because I am not on my admission. I am not on my tender being admitted or rejected or whatever it is, though it has been admitted. Now, your Lordship may kindly come to page 80, Annex 11. An official order is passed. An official order is passed. The tender is revoked due to some technical issues.
That is on 13/10.
13/10.
So, same day.
Same date. Now, your Lordship may kindly come. The next is the date of opening of financial bid, that is on 14th October.
Where do I get it? At page?
81.
No, they have said that the process 1, process 2, but the opening date.
Milords, kindly have a look at the stages, process 1, then process 2.
Yes, I have.
Financial bid opening, financial evaluation.
But no date is given.
No, date is there, Milords. Date is there at the left-hand side top. Thus, below tenders Orissa, the date is 14th October 2025.
Okay. Okay.
Now, this stands admitted. They have stated that we have opened the tender, we have held a lottery. They don't deny this. Now, Milords, the moot question
What is
is,
the explanation it was given? Have they filed their?
My lord, our counter affidavit, Lordship, kindly see paragraph 7 of the counter affidavit.
Oh, don't. No, I have just.
Yes.
This question,
Now-
now take us, I have asked the same question which you are trying to say. That what is their stand on these?
the sum and substance of their stand in the counter affidavit is that all this is because of human and technical errors. One. And I have challenged the rejection of my technical bid, which is not a fact. I am on the simple question, after you revoke a tender,
But your technical bid was admitted.
because there's a flip-flop. First, they rejected it on 2 different grounds. Then they admitted it.
Okay.
That has not been, that has been suppressed in the counter affidavit, that my bid was admitted. Now, I am not on that. Whether it is rejected or admitted, I am on the simple and moot question.
No, I understand.
Yes.
Understand.
And the third point
They
is
have
that
taken the shelter of a human error.
error and technical glitch.
Okay.
And now I find a new definition given to the word revocation, which is in total contrast to what has been interpreted by the Honorable Supreme Court. Now, so far as the jurisprudence is concerned, my lords, it does not define revocation in a particular manner. But I would just refer your lordship to 2 judgments of the Honorable Supreme Court where revocation word has been defined, although it has been used in a different preventive custody matter. But we are on the question of definition of revocation and its
Revocation
consequence.
is really a recalling or something which is not in existence.
And Milords noted civil law, celebrated law, Mr. Jethmalani was arguing that matter. And that particular paragraph of revocation, what does it mean? I'll just point it out to your lordships. I have given those relevant for your lordships' convenience. I have also given a memo of citation. No, this is the remark. Lordship may kindly come to year 1985 Supreme Court.
85.
Yes, my lords. Para A at page 5. (1985) Supreme Court, AR 1985 Supreme Court 697. My lords, come to para 8. Will lordship got it?
Yes.
Should I read?
No, just give me 2 minutes. Yes, no, so it's the key to recalling.
And prior to that, the Honorable Supreme Court, they have been very,
No, they have said that it has not been defined anywhere in a statutory book.
Yes.
Anyhow, they take it of the Black's Law Dictionary. They have not taken out the Wanton's
law lexicon, Webster's, Oxford, Chambers.
but anyhow, they have taken.
Yes. Now,
The general and the generic meaning of the word.
yes. Now, regarding this flip-flop, you reject my tender, admit my tender, cancel the tender on administrative grounds, cancel the tender on technical grounds, all prior to opening of the financial bids. Your Lordships I'm sure your Lordships are aware of the Subodh Khan judgment delivered by the Honorable Supreme Court only last year. Subodh Kumar Singh.
Subodh Kumar Singh is a different.
No, I am purely on the administrative side of these actions. I am purely on the administrative side. I'll just read it out. It's a short paragraph. Page 585. I've given the note of citations. Paragraph 66. It reads as follows.
Yes.
Because your Lordship may come to page 585.
Page.
585.
Yes.
Paragraph 66.
Yes.
Control of administrative discretion is an important concern in the development of rule of law. According to Wade and Fawcett, the rule of law has four meanings. And one of them is that government should be conducted within a framework of recognized rules and principles which restrict discretionary powers. You do not have unfettered or unlimited powers to cancel, reject, again recall. This order of revocation has not been recalled. Now, another very serious observation that the Honorable Supreme Court has made in this judgment. I'll just point that to her. Playing Jekyll and Hyde. Lordship may kindly come to page 575.
Yes.
Lordship may kindly come to
Yes.
Lordship, just give me 20 seconds. 575, para 55, Roman 2.
Yes, quoting the relevant excerpts.
The para in italics, 53. When the offending party is the state, in other words, the contention is that the law in this field has witnessed an evolution and what is more, a revolution of sorts and is a transformatory change with a growing realization of the true ambit of Article 14 of the Constitution of India. The state, he points out, cannot play the Dr. Jekyll and Hyde game anymore. Its nature is cast in stone. Its character is inflexible. This is irrespective of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansion of the frontiers of the court's jurisdiction to strike at the state action in matters arising out of contract. Based undoubtedly on the facts of each case, it remains open to the court to refuse to reject a case involving state action on the basis of that action is per se arbitrary.
But does it go against the spirit?
It does. It does. With great respect to your
last sentence.
Last sentence involving state action on the basis. Sorry?
It remains.
It remains open to the court to refuse to reject a case. That is my case.
It is open to the court to refuse to reject a case involving a state action on the basis that the action is per se arbitrary. If it is arbitrary, then why even reject a case?
It is not only arbitrary. I got your point, Lordship. I got your point. And I am on a weak footing because your Lordship has put me on the wrong foot. I concede to that. Now, filing of a writ petition before the contract is signed or finalized. What have they said? Next page, subpara 3, Roman 3. This is important. This will override what I have just read. An action under a writ will lie, even at the stage prior to the award of a contract by the state, wherever such award of contract is imbued with procedural impropriety, arbitrariness, favoritism, or without any application of mind. I would like to pause here, Millers. All the three words used by the lordship are applicable in the present case.
Favoritism cannot.
I don't know, they're in a big hurry. They're saying that we have already finalized the person. We will be.
There is a stronger element that has to come.
In doing so, the court may set aside the decision which is found to be vitiated for the reasons stated above, but cannot substitute the same with its own decision. The relevant observations as under. An action will lie undoubtedly when the state purports to award any largesse, and undoubtedly this relates to the stage prior to the contract being entered into. Sri Ramana Dayan Shetty Millards, 1979 Supreme Court, page 1629. That is the landmark judgment which every court follows. This scrutiny, no doubt, would be undertaken within the nature of the judicial review, which has been declared in the decision in Tata Cellular versus Union Opinion. Another celebrated judge.
Sorry. So let us hear again.
Yes.
He says, on a parameter of law. Yes, sir. Or you can justify your.
Let's say kindly come to page 4, paragraph 7 of the writ petition. Because some actual aspects need to be brought to us.
No, because the law has to be applied in the context of the facts, not in an abstract. No relevance.
Page 4, paragraph 7. What is the ground of challenge here? That the technical deeds of the participants were opened on 28 paragraph 4, page 4, paragraph 7 of the writ petition. That the technical deeds of the participants were opened on 28/2025. After 4.5 months of having opened the technical deed, the petitioner was informed by dated 10/10/2025 that her bid has been rejected as she had not been satisfied clause 4E of section 2. But stated here that there is no such clause as clause 4E in section 2.
So he has said that these are the prelude to the genesis or maybe the origination of those issues. Every fact may not be material fact. What he's saying, if he has come forward and raised this issue in the prelim, have you stated all these facts that they have revoked, they have recalled, after proceeding? So this is what has to understood from the perspective of this.
Here
we can't take a advantage. Can't we visualize the situation? Had it been a case that they participated with their eyes open, and then they came forward and say that this eligibility criteria, this condition, that conditions are absolutely bad or arbitrary, I would have understood that once they consciously participate at this stage, they cannot take a U-turn and then come and say it's possible. What they say is that here we are not challenging any path. You have rejected, he has admitted that you rejected my bidding at the technical stage. Later on, you admitted my bidding the technical stage. So he's admitting there is no difficulty. I am there. I am also eligible for a price bid open. But when once you revoked the entire thing,
I am coming to that.
And then you open a bid.
Here, Miller,
this is what is the main question.
Miller,
let my friend submit Millards and answer.
Here, Miller, I am trying to impress upon your lordship that Miller. Here, the question is raised by the petitioner that there is no such clause in the DTCR, Miller, under which bid is cancellable.
He is not challenging, please kindly consider, he is not challenging the order rejecting his bid at the technical evaluation stage. Please consider, he says your conduct is tried to be projected before us as such that what you are doing, it's a dilly-dally things which you are really doing. One stage you do this, another stage you rectify, another stage you did this, and then you do another thing which is impermissible. He says that what you did is impermissible in law. If a tender is revoked, then it loses its existence in the eye of a contractual field as well as a law. That is his main focus.
Here, this revocation is constituted. Let's see, kindly turn to page 3 of our counter affidavit here. This revocation is not in that way. It is not being interpreted in that way, Millard. This revocation means, Millard, as per this tender website.
But in paragraph 12, you are admitting.
That revocation, that paragraph 7, Millard.
Yes.
The second paragraph.
Yes.
Subsequently, due to human or system
No,
error.
paragraph. What I'm looking at. Let's see. What's the region? Where is the? Okay. Happy.
Like B.
Yes. Paragraph.
It starts from paragraph 7, Millard.
7.
Subparagraph 2, let's say, kindly have a class.
Yes. Yes, what you are referring?
Subparagraph 2 of paragraph 7, Millard.
Yes.
Subsequently, due to human or system error, an incorrect version of the evaluation document which contained a different erroneous reason for rejection related to moral public sand was inadvertently uploaded to the e-tender portal. This was communicated to the petitioner via.
So this relates to a rejection on a technical evaluation ground. It would say therefore the human error should not have been rejected.
Yes.
And this was communicated to him. No. Your bid is accepted, or it's not disputing that.
It was a system.
I'm talking about the revocation. I'm coming to the
Director, let's see, kindly the next paragraph. Upon realizing his error and after collecting the correct, duly approved copy of the evaluation proceedings from the government in the Department of Water Resources, the opposite parties used the revocation function on the e-tender portal on 13/10/2025. This was purely technical and procedural steps to nullify the incorrectly uploaded document and bring the tender back to the technical bid opening stage. This allowed them to upload the correct and approved version of the evaluation document, which consistently cited in petitioner's non-compliance with clause 4E as the sole and valid reason for rejection. Director, let's see, kindly turn to paragraph 10, 11, 12. They have given the sequence. Paragraph 10 at page 6. That due to technical issues, the opposite party number 2 revoked the tender on 13/10/2025. This revocation, they mean, Millard.
And how you intimated that your tender is now considered as valid at the technical bid stage?
Director Millard.
Please.
On that day, at paragraph 11, at 3:30 p.m. on 13/10/2025, the petitioner has been intimated that her technical bid has been rejected on the basis of tender committee decision through her email ID, which is an automated system generated mail issued from the tender website. At 6:53 p.m. the same day, Millard, revocation was required due to some error or due to human system error. An incorrect version of the evaluation document was uploaded and erroneous email annexure 10 of the petition was sent to the petitioner stating that his financial bid was accepted.
Correct.
This was
His financial bid was accepted means he passes successfully through a technical bid stage.
This was an automated system generated email. At next paragraph 13, at 7:35 p.m., due to the corrected, duly approved evaluation document was uploaded. The petitioner status remained rejected.
So,
No evaluation, no re-evaluation occurred. Again, Millard, the petitioner through her email received a system auto-generated rejection mail. The said information has not been deliberately disclosed by the petitioner, Millard. It is not disclosed by the petitioner, Millard. Now, Millard, so far this revocation, what is being interpreted, Millard? It is not the revocation of the entire tender. Had it been a case, Millard, it would have been cancelled. It is only to undo something which is inadvertently uploaded in the website, in the portal, Millard.
oh, I understand.
That is the
Then,
intention.
then what is the meaning to be assigned to this word?
Page 18.
The tender has been rejected. What is the meaning of this one? The bid or the tender, there is a vast distinction between that.
Millard, the bid is rejected.
So why you have used the tender as completely?
Millard, that is inadvertently.
Then inadvertently again you said in the second page that administrative region has been revoked.
Millard, revocation means, Millard, that to undo
So
something.
this is something which does not carry any meaning.
Yeah.
Yeah, page 78 also.
Yes.
What you are trying to say, it does not appear from a very simple reading of the English words.
Millard, actually, Millard, let's you kindly turn to page.
They are educated persons,
Yes.
so they know how the importance of the words, English words.
Millard, page 39. Let's you kindly have a glance. Page 39 of our counter, Millard, that document we have found.
Yes.
Page 39, Millard. Some portions I am trying to let's figure out. Page 39, serial number 25, Millard. It is allowed to modify the bid through e-procurement portal. The bidder shall have to log
Just 39.
page 39, Millard.
Yes. Clause
25.
yes.
Let's see, director, let's see, that may refer to clause 30.
No, it is allowed to modify the
Yes.
bid.
These are some relevant portions, Millard.
What is the meaning of the word bid?
It is submitted by
What is submitted by the participating tenderer
Millard.
that they may be permitted to modify the bid which they have submitted through a e-procurement portal. What is that? That the right is given to them to modify. What is your right?
Yes. Let's say may come to same page, serial number 30
Bidder shall
and 31. Millard.
and be subject to the document. This is what is given to them. Yes, then next.
Next, Millard, page, next page, let's see, may see
Clause
clause 31, Millard.
31. Therefore, absolute right,
Concede.
absolute right.
Millard, here what happened, Millard? That is not actually the tender was not revoked. Only
Then what is the meaning of the word revoke? Given by the judicial pronouncements.
like here,
What is the meaning? I think revoke is used in that context always.
so far this revocation is concerned, Millard, this word, meaning of this word is concerned. They're deriving it from the portal, Millard.
Deriving means your portal is tailored or designed in such a manner. From the word revoke, you cannot use any word. It is not in that sense.
It is only
It is what you just put commands into it that will be reflected. You can add 3 sentences, 4 sentences. This will come because your decision is reflected there. Revoke.
Millard, if it is for personal consideration, Millard, if it is revoked, Millard, director it also proceeded. There is a lottery winner,
What is
L1
the
bidder
very
was-
big question mark which he has raised, that if the tender is revoked, then how can you proceed on the basis of a thing which becomes non-existent?
Actually, my lord, it was not revoked. Subsequently, it was
Then how
corrected, my lord.
to be given? He has used the word revoke.
And it was communicated to them to upload the correct document.
That's why if a person understands, a common man, when he receives the mail, he understands the meaning of the word. He may not have taken any steps that once you are revoked, now there's nothing to go about it. You will float the another tender and participate there in a way.
That is my prayer. Sorry.
You have compelled a person to alter his position. You would have challenged that particular order by which his technical bid his bid was rejected at the technical stage, citing a particular clause which is non-existent in the tender document. That was his stand.
Well, that is actually inexistent. That is not given in the writ petition, my lord. That
What-
clause.
I do not know. That is not an issue. He could have come to the court.
Yes.
And the court may decide whether it is there or not.
Yes.
You have just made him not to approach because he subsequently found that once the tender has gone, what is the utility of going and challenging this? Is a mere academic.
My lord, so far this word revocation is concerned, my lord, that is actually designed in that way, my lord.
How can we, judicial recognition of a word is there, can we decide something different? The meaning is also different.
That's it. Paragraph at page 17 and 18, my lord, it is also explained
What?
that due to an inadvertent uploading error, an earlier version of the evaluation document was placed on the portal. To correct the same and to upload the duly approved version of the evaluation.
Yes, where is the newly version where you have removed the word revoke?
Evaluation proceeding, the revocation
Where?
option.
Where? You just tell me where you have newly version, you have.
No, minute. I'm reading from page 18, Miller.
Yes.
First bullet point. To correct the same and to upload the duly approved version of the evaluation proceedings, the revocation option was used as per the facility available in the e-tender portal annexure 11 to the writ petition, Miller. This technical step merely brought the tender back to the technical opening stage to enable the correct upload, Miller. That was designed in that way only, Miller. Designed in that way. And the petitioner was aware of that while uploading in the tender portal. When the wrong document was uploaded, an auto-generated email was sent to the email ID of the petitioner. Thereafter, when it came to the notice of the department to undo that, to rectify that error, Miller, this revocation option was locked in. That was the option available in the tender portal. That doesn't mean that entire tender process is revoked. If it hadn't been a case, then thereafter they should have not proceeded for lottery. And in the meantime, lottery has been conducted and some person.
Can you show me from the site that there is a absolutely revocation icon which is given? And in what sense this revocation icon is used?
That's it. Everyone.
No, sir.
Tomorrow I
Not
ask you.
included it. You have filed your conscience.
For this technical parties. Take up this matter tomorrow as fast item.
No, sir.
I will assist you.
That was there in the instructions to bidder how to continue with the steps to upload the documents and this function key or menu, whatever you say.
That's it. Then kindly take up this matter tomorrow as fast. I will come with that decision.
Whatever
But this is I'm blessing from the counter evidence.
position or in your counter will go there. It will not go beyond.
So my certificate
It is
tomorrow and
only,
fast.
only a passing observations that have you have not.
It's there.
Whatever
As per my instruction, it is there.
you could have anyhow. You shall annex a copy of that particular screenshot
Yes, ma'am.
which you have not found.
Yes. And so far this clause 25 and other provisions in the tender document is consumable. They can change it. That uploaded document, they can also change it, and the department also can change it. Rectify the error. And the word is used as revocation in the portal. That is the reason. But the process was not revoked.
Yes.
You given your site address which you have given. Oh,
And the reason for rejection is that they did not upload the document as per the tender condition, DTCL condition regarding what they are having in their hand at the time which relevant time, at the time of applying for the bid.
Yes. Anything more?
No.
No, it's just 20 seconds. When order is meant to be changed or this thing as per the OPWD code, it's not my version. Modification of order is passed with an addendum or an original. Have they recalled that order of revocation as per Annexure 11? No, emphatic answer. Have they issued a memorandum or a corrigendum to the extent that this order stands modified? Emphatic no. This is the provisions of the OPWD code. Now, my learned friend on the other side is referring to certain portions of the agreement which does not have a bearing on this case. No opportunity was given to me or any other participant for the matter to modify our bid because everything happened on the 13th. And one fine morning you get up and say on the website that your financial bills are being opened. Not even 24 hours. And nobody works so late in the night. And the word revocation on their computer. Their assertion that there is a separate icon for the word revocation in their computer, that does not override the judicial pronouncements of the apex court. They may be having
any word which is used has to be used in a sense in which it is so used.
Absolutely.
The word may contain a meaning, and if the meaning can be reasonably gathered.
Yes.
So using that, their condition is something different. This revocation has to be used, has been used in this perspective.
Yes.
And which should be reflected.
And Milord, what is my prayer? My prayer.
So with the revocation, when you talk about, then the revocation is very simple. They have used this revocation that this tender has been revoked. Then in another word, from a technical evaluation to technical.
Yes.
Revoked means that from a technical evaluation stage, and it has gone back to a technical opening stage.
everything
That
from,
means everything they have to re-evaluate
yes,
the technical fee. So revocation is used in that sense,
yes.
not in the sense of revoking the tender as a whole.
And what is my prayer, Milords?
But anyhow, there is no answer to this regarding this page 80 of the report,
There is no answer for so.
where it is very simple. Authorities have not explained this letter.
It is,
No, not inverted. Straight, page 18
yes,
is not an inverted one.
yes,
It's a letter. It's a letter, not computer generated.
That's an order.
Pertaining to the same bid,
Sorry,
page 80,
page 80.
same bid.
Same bill. It's an order, Milords. It's an order referring to the same bill. Bid procurement e-notice and then the tender title. Your Lordship will come across it on the first page of the writ application, tender title. And e-procurement is the notice. And it says revocation of tender. It's signed by no less a person than the chief engineer and basin manager. This is purely official.
it is explained in the counter. Let's see, page 15, paragraph 21 of our counter. That document is at annexure 11, and that is mentioned in paragraph 11 of the writ petition. That is explained in this way. The revocation in question, that is the annexure 11, was carried out solely to rectify a technical error in the document uploaded in the e-tender portal. The term revocation is a technical terminology used with the e-tendering system, which was used in this present case to undo or reopen the tender stage for uploading the corrected document. It doesn't imply any re-evaluation or alteration of the approved decision of the competent authority. So, that in the instant case, the technical bid evaluation proceeding were duly examined and approved at multi-levels of the government. There are 3 levels. It is also approved in all these 3 levels. These document under Annexure 11, it is only issued to rectify the error in the portal. That was the written version of that. That is what is explained at paragraph 21.
Milords,
And Miller at page 18, so far this annexure 11 is concerned, Miller, that is specifically answered to Miller. Due to an inadvertent uploading error, an earlier version of the evaluation document was placed on the portal. To correct the same and to upload the duly approved version of the evaluation proceeding, the revocation option was used as per the facility available in the e-tender portal, that is annexure 11 of the writ petition. This technical step merely brought the tender back to the technical opening state to enable the corrected upload. That is annexure 11 is explained in this way.
You do not deny the genuinity, veracity of this letter, election 11.
No, that is explained in this way.
Milords, I read out the judgment of the Honorable Supreme Court delivered by very recent judgment. This system error, what they have stated, system error. Your Lordship may come to page 3 of that judgment. Bullet point 2. Bullet point 2. The appellant claims that they discovered the mistake on 24/8/2023 when the financial bids were opened and announced, and therefore on the next day, 25/8/2023, they informed the authorities that their actual bid was for rupees 1569 crores and not 1569. They attributed the error to a typographical mistake or a critical technical issue with the server. While we would not accept the plea of system error, the figure quoted was clearly unrealistic, a patent error, and a mistake given the scale and nature of the work tendered. Now, Lordship may further come to page para 9 at page 8. Should I read it? Para 9, page 8. The decision in West Bengal State Electricity Board was referred to and followed where a relief to the bidder was apparent before this court in so-and-so case. This decision observes that while the court must exercise a lot of restraint in exercising the power of judicial review in contractual commercial matters, the doctrine of proportionality nevertheless applies when the error or mistake is writ large and equity merits the grant of some relief. Reference was made to the decision in Coimbatore District Central Cooperative Bank versus Coimbatore District Central Cooperative Bank Employees Association and another, where discussing the question of proportionality or punishment imposed on the striking working man, it is observed.
That is on a different note.
No, this para 11 of that judgment, they have stated, para 11, page 10, at the same time, we agree with the BRO that the appellant was at fault and he had made the mistake of having failed to add the requisite zeros in the financial bid. The plea of a system glitch should not be accepted as others had successfully uploaded their bids without a problem.
That's all.
Dictation. First matter, we'll dictate. We'll dictate tomorrow in the first morning.
Item number 7.
The positioner is challenging.
Maybe taken up on next first. Oh, already informed her.
But can it be taken up in the week commencing 16?
First, man, giving the answer.
18.
Okay.
Item number 8.
Senior friend, popularly is coming.
This is what matter.
This is that deforestation matter where Lordship had appointed my Lawrence senior.
Yes. What has happened?
Yeah, the petitioner has filed an affidavit pursuant to Lordship's direction on 7/1. Lordship's in the last order, 7/1 order.
So what?
Lordship had directed because she had got certain facts to your Lordship notice stating that certain areas where deforestations are occurring.
Okay.
Well, that was the matter. Lordship had directed her to bring on record actual facts what she has with her.
Because orally stated that 1,000 to 1,500 trees are being felled every day in Bargad and in other forest division. So therefore, Milos directed to bring it an affidavit with supporting evidence, and Milos has also directed us to file affidavit. We have filed the affidavits, but it has not come on record. We had e-filed it. It has not come on record and giving the hard copies.
Has she filed?
She has not filed. She has not given any copy to me.
Mr. Shukla.
Tell her to give a copy. Why you will not give a copy to them? Dr. Shukla, why you will not copy to them?
Sir, I have filed through Unicus assistant. So
And as a
I did not have.
now they are filing an affidavit which is not on record. You will have to go through it.
Sir,
I think we can share a vote.
I'm also giving.
I will
Yes.
supply.
Doctor, pursuant to the earlier direction, Dr. Shukla, the petitioner has filed the affidavit.
Underqualified 20%, they are occupying the professional pool.
Difficulty is Mr. Sashwata Das is suffering from high fever since yesterday. So he was also not attending. He is asking for a time because he is not available and he is engaged in the matter. Do you oppose this prayer?
Well, although I am not opposing, but your lordship have already concluded the things.
Whatever,
Opposing a question, that is
whatever, when the matter is listed,
we have to satisfy, my lord, within that purview, whether it is.
do you want an ex parte hearing to be done? Be straight. I am on that. Either you say I am opposing this prayer, so we will not.
I cannot in this circumstances.
This is what is.
I know, my lord, what is our
Yes.
podium ethics, my lord. But one thing, my lord.
It is a human ethics.
My lord.
If something. So next week it will be listed.
But I will talk, my lord, so that
It is fairly at the top at item number 10. What more?
After waiting for at least 2 months.
Sweet.
That is why, my lord. And in this case, at least 60 days has been passed. Matter was hard, my lord, my lord.
Whatever means when the matter is there, you wanted to make a clarification, then a further argument. So in his presence, you do it. No difficulty. Next week.
Item 11.
At the top of the list, my lord, so that we will be ready. But only short, my lord. Only point wise, I have to all the 6 points with authority, and that should be closed.
Item 11.
Like the case of successful completion of the work assigned by the railways and they're releasing the final bill. Let me kindly turn to page 26.
Just 1 minute. So you wanted a GST neutralization.
No,
That is the first order I could read 27/8/2024.
and here they are not releasing a final bill in spite of successful completion of the work. But they are bringing in
But the bench has recorded something new.
Well, now they are bringing in the theory of GST.
I do not know. It is, you are for the petitioner? You are Mr. S.S. Paddy? It says Mr. Paddy, learned advocate, appears on behalf of the petitioner and submits that his client executed work for railways under the contract. Impugned is the letter issued requiring his client to obtain GST neutralization
By the railway
in respect of a work done. That is what is not there.
Railway is requiring GST neutralization. That's what they impugn here. That requirement of GST neutralization is impugned here. And kindly turn to page 26. So also to kindly see this is the letter of acceptance that the railways pursuant to the tender. Kindly see the reference. The tender notice was issued on 2/5/2017.
No, understand. Yes.
The date of opening, the technical bid opening was on 6/6/2017. Now, can you see in the meantime the GST has gone. Thereafter, the financial bid was opened on 25/7/2017. Since in the meantime the GST has come into court.
Now, date of negotiation is also fixed later on.
Yes. So post GST, they have held a negotiation where I have admittedly reduced my bidded rate, because of what for GST?
Because GST is to be excluded.
Yes,
Earlier it was inclusive of tax. Now exclusive of tax.
Yes, so for this negotiation were held, I reduced my rate. Thereafter, this letter of acceptance was issued by the LP. But may I kindly see also it's a total value of work is 20 crores some more.
Yes.
I will draw your attention to two clauses, page 76. It's a part of the conditions of the contract. Clause 38 at page 76.
Yes.
the contractors are here in full all taxes, royalties and other taxes, duties levied by the state government and or central government from time to time. This would be entirely a matter between the contractor and the state government or the central government. Railway will recover the taxes and royalties through running account bills if the contractor fails to produce the document. But a similar clause you also would find at page 84.
Yes.
Clause B. Unless specifically provided for in the item, the rates quoted for all items of the schedule shall include the cost of one all tax.
Yes.
So what I beg to submit was that my rate was inclusive of all the taxes. Now kindly see, you'll also kindly turn to page 88.
Yes.
This is a supplementary agreement entered into between the railways and the petitioner on 20th February 2024.
Yes.
Wherein, work of 20 crores has been reduced to the extent of work executed. That is 5 crore 48. You'll also find this at
Yes.
in the first paragraph from the bottom. I'm reading 6-7 lines above.
No, I have read it.
Yes, no. Just for recap, let the approximate quantities and basic rates as given therein increase, decrease by the accepted tender percentage, and whereas during actual execution of the works, the approximate quantities as given in the principal agreement have varied, resulting in consequential reduction in the agreement value from 20 crore some odd to 5 crore.
Yes.
So to the extent work executed, this has been the work total value has been revised. Consequent to this, the railway has asked me, you furnish a no claim certificate that you will not claim anything for this reduction in the scope of work. That the petitioner has furnished at page 101, answer 5. We hereby undertake that we have no claim against the railway administration for quantity decrease.
Anyhow, so that's a ratification. So you have done.
Now is page 102, annexure 6 is my final bill within that 5 crore 8, within that reduced value of the work.
Yes.
Now this has not been paid, but this final bill has not been paid, and the reason of their non-payment is annexure 1 is the imbue.
Page
20. As requested by your letter under reference was forwarded to FA and CO for further action, but Deputy FA and CO by letter dated so and so has mentioned that the opinion of GST consultant has been obtained, wherein it is opined that neither the impact of GST was analyzed nor considered while making such negotiation as evident from the TC meetings, and letter of the contractor and tax neutralization is required as per para so and so. As finalization of the tender was made without considering the impact of GST, the copy of it. In the light of the above, you are requested to submit your GST neutralization for the said work to process further at this end, please. So my humble submission is that at the first point of time after coming into force of the GST, you held a negotiation. Thereafter, in 2024, you are entering with me a supplementary agreement revising the value of the work. So now, when I completed the work and I have given no claim certificate, you ask for no, you again the tender, the work value has to be recalculated. I mean,
what recalculated? It does not want. They want a GST neutralization.
So that neutralization, first the negotiation, then 2024 agreement. What prevented them when I completed the work, I submitted my final bill, no claim certificate. Then for them to come and say, no, again the work value has to be reworked. They say that now it has to be GST neutralization has to be done. But that, in my humble submission, has already been taken into account in the negotiation, and in any case, 2024 agreement. In 2024, you are entering an agreement with me.
not obligation of the railway to deduct the GST component deposit.
GST TDS they were making, that's not in GST TDS they were making. I am not
TDS the
last bill also they deducted TDS. In fact, what I'm saying is 5 crore 48 the contract value that is sacrosanct. That includes the taxes which to be borne by me. If I'm not discharging GST, then I will be chased by the GST department. And as a matter of fact, from all the bills, they were deducting GST TDS. Not what they now is saying that this 5 crore 48 is to be reworked in view of the GST neutralization. That in my
why GST
I have unable to understand that what it has come. To be very fair, let me understand this particular modality is what they wanted to work out and what we understand into the regime of a GST. Sir, if you are supplying, say supplying a goods to your buyer, then you have quoted a price that this will be the rate of each item which I will be supplying to you. And if there is any GST which is exercisable on that, then I will quote that GST. So say for example, if you have quoted that 4 rupees a price per piece, and then it attracts 1 rupee GST, 5. You will raise a bill for 5. You will raise a bill for 5. Now I am coming. Let me understand. There is an ambiguity in my mind.
I am not separately quoting. I am not separately quoting.
Please let me. That is what a problem with now the younger generations. They are impatient. They do not want to listen patiently. Sir, if there is some confusion or ambiguity in the mind of our judges, I think it is a most important duty of the council to eradicate that confusion. What is troubling me with the word is GST neutralization. I am very conscious of that it is inclusive of all taxes. I will come to that, but I wanted to proceed on some basis. When you raise a bill for 5, which is 4 rupees for a price and 1 rupee of GST cover, what normally is done that they will make you a payment of 5, correct? And then it is your obligation under the GST Act to deposit with the authority 1 rupee, which you have collected. I'm not going into the ITC or something like that. Let us go in a straight manner. 1 rupee. You have, they will definitely take an advantage of this particular payment of the GST to you in case of a future payment of GST by them. Not difficult, but they will pay you. Now, if that being the position, then in that event, a particular price, suppose a 5 rupees per item is quoted by you with the clear stipulation that it includes all taxes. Now you do not know what is the component, or he does not know what is the component of tax. True. Now what he has done is that he will deduct the TDS because it is his obligation. He will calculate it on the basis of 5 rupees. Deduct. But while discharging your obligation, you have to calculate the GST on the basis of the materials, which may be less than 5. Obviously, which is less than 5. You may work out on a basis of 3 rupees. You may work out on the basis of 3 rupees 50 paisa, and then the GST component. Then you are depositing with the GST authority and taking advantage of the TDS which they have already deducted as a discharge of your obligation. So you have to work out that what should be the quantum of the GST on which 5 crores something. It may come to 50,000 rupees, it may come to 1 lakh rupees, or it may come to 30 lakhs rupees. That is your calculation. Now what they want, since they have paid you a GST, this is what is troubling me. Since they have paid you a GST, So they wanted that what amount of GST you have deposited with the authorities so that they will take advantage of those deposits for their future transactions where they have to deposit the money. So they will take a neutralization, they will take a deduction of those amounts already deposited and then will make a further payment, the whatever. So this is what they wanted you to just give me the total receipts which you have deposited in respect of this. This is what I understood. Whether it is correct or it is wrong, please correct me. This is what I understood.
If this should have been the fact, I have no case. They have a right to ask me what GST you have discharged. That right they have. If that would have been the case, I have no, I would not have come here.
Then what is the case?
What now they are saying? Suppose the example your lordship has given, 4 rupees, 1 rupees is the GST. What they now saying that 4 rupees, since this contract was floated or this tender was floated pre-GST, so all the items of work that we have estimated by taking into account the pre-GST tax regime. So since the work was executed post-GST, those individual items of work has to be again revalued to see whether the tax repercussion on these materials were more or less.
I don't think so. This letter talks about that.
Yeah, that's what GST neutralization is, Malak. So there is no dispute as
What is
regards
the meaning of the word GST neutralization?
that your lordship would kindly find it. The ZPC have annexed.
Let them disclose their stand that what they really wanted by this letter. What is your stand?
Lordship, for this, my learned friend is saying about GST neutralization and whether this tender was floated in the VAT regime and what is the impact of after coming up to the GST regime on the question. Lordship, for a moment, I'll just show the negotiation letter, if my lord kindly permits me. That is page 197. That is the sole dispute. Why GST neutralization is required in this case?
Yeah. What is the meaning of this word
GST neutralization? There is some impact under the VAT regime. And after the GST, because individual item.
GST, the quotation of bids were made inclusive of VAT without disclosing the component of taxes separately. Right? When the bid was under contemplation, GST regime is setting. You wanted, there is modification in price structure. The quotation. So under the GST regime, it is GST exclusive. Price it could go. With eyes open, after negotiation, you have made a supplementary agreement. Can you resign from that now?
Here I want to.
Where you have written that the price quoted, that 5 crores, that will be inclusive of all taxes with your.
But that was as per the VAT regime, not GST regime. In negotiation.
In 24.
Sir,
that is only with respect to the volume of the work.
Is the thing which is not in existence. And the negotiation has come when the new regime is already there. What is the purpose of the negotiation?
In the negotiation, there was only to the extent of volume of work, not respect to the tax implication on the volume of the work. Lordship, kindly see that Lordship. Lordship, may kindly see one. I was showing your Lordship 197 page that is regarding the negotiation.
Which one?
197. This is what about the negotiation you must see.
197.
This is the counter book, sir.
Composition of tender committee.
197.
Minutes of tender.
You have not received the counter. I have already given it. No. I'm so sorry. I will file the counter on 23/10/1/2025. I have already filed the counter on 10/1/2025. But my friend has not received.
These are council through. You have not given.
No, you have to.
Then show me that you have given one copy.
But here mail sent copy counter copy, sir. But it's a noting. If it is not, then I'll serve the copy. I can serve it on WhatsApp mail as well now.
I should have also checked the cause list. I should have.
Sir, I'll serve the copy.
It is not in short, but the cause list shows, so I should have at the beginning also stated. Cause list also shows that counter affidavit will be filed.
It is a study like this.
You give him a copy first, you just go through it.
You take this one. My lord, I'm serving the copy, I'll take it print off.
Close of the hearing, well,
Already. The concerned officer has been transferred and
whether there is already a directive.
Yes, there was a direction. It is prepared. Self-working, Your Lordship, only 7 days time. Next week, Your Lordship, call.
To 25th June 2012, the directions filed positively.
25, Your Lordship, it's my mistake, but I need only 7 days time. Next week, Your Lordship, meeting.
The extension has been granted for you.
I'm sorry. I am conscious, sir.
I have a very uniform principle.
Your Lordship, I'm
Clear cost. Deposit notes.
only 7 days time. Your Lordship.
I always allow first extension, allow any directions, but from second one.
It only needed a little clarification and some administrative.
First, the original order.
It's my approach. I beg apology.
Third extension.
Also, beg apology, only 7 days time. By next week, I'll file the counter.
Very long. Very long.
No,
Honestly,
Sorry. Is which is the organization?
Railway.
East Coast Railway.
Let them deposit in the court.
As a last chance, Your Lordship.
As a last chance. We are giving you as a last chance, but subject.
so that positively means what? In April.
At the time of admission of the incident petitions.
very uniform view in this.
The amount cost of being imposed. The payer you also.
You are doing for a good cause,
Yes.
not going to them.
Item 13.
First opinion, you justified order sheet 7/1/2026. You directed the state council to take instruction in pursuant to the letter dated 10/2025, where it has been
Recommender? Right?
revision, but I have an additional affidavit where I have mentioned the present status of the case. Your lordship has directed to take instruction to that effect last occasion.
Let's see the prayer at page 13 here.
Page 20, my lord. Last occasion I have given that I have already cleared all the dues and there is no issues comes that is 10/12/2025 after filing the counter, my lord.
Blasting permission.
Only because there is blasting permission, my lord. That's why I have already deposited 40 lakhs. And since 2022, I have my lord, work order has been issued.
You are issuing the blasting permissions.
Actually, the collector has to give permission to blasting here.
Now, whatever be, then what is he as a layman, as a person, what he's supposed to do? He can comply all the formalities, but will you sit over the matter?
No, Miller.
So
we have not
either allow or say if you have rejected, refund the entire money, pay back.
No, Miller.
Then what pay? No.
Prayer is of twofold, Miller. First is
forget about the prayer. Now, by passage of time, what has happened? This is a 2024 scenario.
Yes, Miller.
His grievance is that why you are not granting me a blasting permission? Why you are sitting over it?
Yes.
That's your grievance.
Yes.
That's all.
No, Miller.
No, Miller.
He applied for blasting permission. That was rejected by the collector. He challenging that order, the rejection order, in the first prayer of the repetition.
Correct.
And
why it is rejected?
Well, it is rejected on two grounds. First is Miller. He is having 3-4 criminal cases against him. And the second one.
Have you terminated the mining agreement?
Miller, second.
No, I am just asking. He has 2-3 criminal cases against him. Have you terminated the mining agreement?
It is not terminated, Miller.
Not terminated. Then, second ground.
The second ground is Miller. One tribal village is adjacent to the area. That's why blasting permission cannot be granted.
So no mining activities can be undertaken there.
Mining activities can be done, Miller. They have not annexed their mining plan with the repetition, Miller. The mining plan shows that it is semi-mechanized mine. They can do in other way.
What is the other way?
In manual way, they can also do that.
How? With the hammer and
yes, Miller. They have already specified in that mining plan. Miller,
hammer.
Yes, other machines they have also hammer, other machineries they can deploy.
To cut these stones.
Yes, other machines, Miller. I will file the mining plan, Miller, along with
without explosion also it can be done.
It can be done. Miller. That is in that.
Surface mining or underground mining?
It is.
It is surface mining or underground mining?
It is surface mining.
Surface mining.
Your lordship kindly see page 22, my lord. What the Tahsildar, my lord, is saying, my lord, the license is to page 22 of the writ petition, my lord. My lord, page 22, my lord.
Yes.
Where my lord Tahsildar has stated about the views regarding blasting permission, he has stated categorically by a licensed explosive drilling and blasting shall be done by only by licensed explosive agent. by the proponent after obtaining required approval from the competent authority. I have entered into an agreement with my authorized licensee minor. I have given that agreement also. And also face agreement has also been
Where is
executed.
the order of rejection?
Okay.
My first writ application, my prayer was for issuance of blasting permission and not to impose my demand. They have also imposed demand payment of that dues.
Milord, that is an annexure D/6 to our counter affidavit, Milord, page 13. That affidavit is filed by.
Something else. That is with regard to some offense.
Yes, no.
Last part.
Which one?
Rules 20.
No, I am just looking at one after another. Case 22 is a letter dated 29/9/2022 issued by the Tehsildar.
Yes, sir.
Which says that the rigging and blasting shall be done only by a license required approval from the competent authority. 23 is the 7/10/2022 references of 27/9 letter. I'm really surprised that this is to inform you grant of blasting permission is not coming under the purview of the State Pollution Control Board.
Yes.
So this is the regional office of the state saying that it does not come within me. Then it is requested to dispose of, do not know, the blasting permission application regarding blasting permission of such and such located at such and such from your kind office. Means deputy collector, judicial office, collector, I do not know.
That is communicated to the office of the collector.
Correct. Then come to 24.
Yes.
He has again written, I have obtained all the government permissions and it is writing to a collector requesting you to give me a blasting permission.
Yes.
Then 25
These are
is a notice of the file.
Official communication.
Yes.
Notice.
What is this?
And clerkship will find at page 26, Miller, at serial number 2. That first, what was the observation given by the SP Khordha, Miller?
Yes.
One and second one, clerkship will see the serial number 2, the second one.
No, this is SP Khordha says one case number such and such, such and such. And he has no experience in running a stone quarry. What are you talking about?
No, Miller.
The SP is giving.
Miller, second one, allowing of blasting in the quarry.
I am talking about the first one.
Yes.
No experience.
One cognizance case.
SP will decide.
SP.
Has he got an expertise?
No, Miller, not at all.
So,
yes,
allowing the blasting permission with a threat to the life. That means he has no experience, so this blasting permission should not be given. That is what one can inculcate. Then the second observation from who?
Second observation, allowing of blasting in the quarry located within 1 kilometer of Porichola Adivasi site.
Oh, that I have seen.
Yes.
Then why you have given a quarry permit to him?
Milord, it is semi-mechanized.
Sorry, we can't. Then the Tehsildar has recommended drilling and the blasting will be done after obtaining a permission from
only a recommendation. That's a kindly see, Milord.
And how the SP can say who is the granting authority?
Yes, Milord.
The Tehsildar has acted beyond the statute book.
Tehsildar only recommended.
What?
That means he has applied his mind. He is the field officer.
Yes.
He is the field officer.
Yes.
He verified the field.
Yes.
He knows the field. Then he has recommended.
It is only recommendation.
It could not be mechanical.
Let's see kindly.
The recommendation cannot be mechanical.
But the statute is different, Milord.
So
this mere recommendation, it is not binding upon the collector, the issuing authority. Let's you kindly see Rule 33 of the OMMC Rule 2016. Some provisions I am demonstrating.
And who is that?
I am coming to that.
Who is that?
Here.
He is setting to apply his fine
Collector.
mechanically, and you will defend this way.
Collector
And he has
is
only
not
recommended the higher authorities will go to.
Very interesting, very interesting. I could notice from page 27, noting number 4. Even a forest department, everybody, Tehsildar, everybody, environmental department, everybody. And then say, this is with regard to the issue of blasting permission in favor of the petitioner. Then it say that we ask for the feasibility report regarding the blasting permission. Reports from all authorities have been received. Though all have allowed for blasting in the silage source, namely such and such stone quarry, but SP has objected.
Yes.
And he is the competent authority.
Who are the persons who gave the administrative officer?
Yes.
Then Tehsildar, RO, SP, CB, and the state pollution.
Basically, the
State Pollution Control Board.
Yes.
DFO, Forest Officer, EFO, which is environmental clearance. Then environmental clearance. Everything has been given. SP has an expertise. If it is done in a regulated manner, which will not cause any.
For the sake of protecting these officers, don't.
And then at the bottom, noting 6, as proposed, the collector and the district magistrate says.
So SP is over and above.
The only thing is that it is.
But you said the recommendation is only recommendatory, not binding.
On the
Pollution Control Board says nothing. Then everybody, the forest officer says nothing.
Fire officer also.
Even fire officer says there is no problem. SP.
No pollution.
And the ground is, it is nearer to the tribal.
Who has said?
Others,
Your
they do
has
not
not
know. They do
Your
not know
collector
other
has-
authorities. They do not know that what is near. Tehsildar does not know. If he has a criminal case and the SP is saying that he has no experience of quarry. He has been selected.
Yes.
So, without going through the eligibility criteria, without going through any other document which he has produced. And if the authorities have considered everything, it's the SP who says no experience. Whether he has an experience.
Certainly, SP has no experience in mining.
No. And if he has a criminal case against him, then why don't you terminate? You have not terminated this. What can you define?
As per their mining plan, they can do it.
Sir, everybody has recommended to give a blasting permission.
Sir, this case is of the year 2016. Now we are in 2026.
5-year period has gone.
You are after him to stop his livelihood and doing the business.
Already done.
Already. And taken his money also.
40 lakhs.
Taken his money also.
Recently has deposited.
Yes. Previously, at the time of taking the inquiry, Have you deposited some money, some?
Yes, my lord. Yes, my lord.
That is
Yes, that is,
the contribution towards the DMS fund.
yes, my lord.
That was deposited.
Why you are taking this contribution? Without giving, is the gratuitous act? Or it is a statutory liability attached or attributed to that particular permission of a query? Can you take it gratuitously without anything in that fund? Only you can collect it from those persons who have a query permit.
I think that area is also famous for that. What is? Nowadays, they have to do.
Can't do it. This is something which
I
is
told you to.
Let
nothing. Yeah.
said we reconsider.
It's what reconciliation. It's absolutely. I do not know. He has not claimed any compensation as of now. The fit case for. Agreement has been executed.
Yes, my lord. Work order has been issued, my lord. Lordship kindly see. Annexure 2, my lord.
When
At 27/5/2020.
22,
my lord.
5 years from there.
3 years. 3 or 4 years.
No,
4 years.
Another 1 year
is of 5 years. So now it is going to expire in 2027. Then that if there is a criminal case pending, no blasting permission. For blasting permission, is there any promise? No.
Criminal case के लिए मौका.
Assist your worship and prepare sort of manager or village organization. It's a case of order passed by the government rejecting the application of the petitioner for grant of all supplies. Informed order at page 18. Worship will find that precisely there are 2 grounds on which it is rejected. First of such ground is they are saying that there are 7 objectionable places in the vicinity of the proposed location applied for. Secondly, they are saying is an application of there are 7 objectionable places within the vicinity where the location of the shop where it is applied for. And second, they are saying that this application of 21-22, so therefore it cannot be issued in the year 25 or 26 whatever. Now, these 2 I have answered in my comparison. With regard to those objectionable places, there are two answers. Within the same vicinity, same locality, there are 7 shops operating, which the government has allowed. The restriction. 2, over the location which I have applied, there was itself a shop operate or sub operate. So I cannot be discriminated. I am relying on your lordship's order, very respectful of your lordship. There cannot be discrimination. Second, with regard to this influx of time, you cannot take such a stand because after I submitted my application, and the period is over, government itself is passing an order to reinvestigate, re-inquire and submit a report. And thereafter again, twice orders after the period is over, you are yourself delaying it, then you are taking advantage of your own rejecting application on the ground of influx of time. And that is what if your lordship sees only one order passed, earlier order passed by this honorable in another case,
that this cannot be ground to reject the application. Influx of time cannot be ground to reject the application. Because you yourself are delaying it by directing re-inquiry, directing the submission of report. And Commissioner has submitted a clear favorable report to grant license saying that there is huge demand in the law. If Lordship could just see that report.
It's a huge demand in the
Locality. Yes, that's what Commissioner says.
That's the most, I think, is a social issue which you have to address. Government has to address. It's a big social issue.
Yes, government has to spend money for that also.
No, it's the issue. No. Take care of that. Why there will be a huge demand there? In the locality.
Kindly see. One after other reports are saying there are demand, may not be huge. As I said, I might have used a word which is not there in the report. Kindly see. Kindly similar, page 44.
No, this, there is a demand.
There is a demand. The word huge might have fallen from my mouth.
Is met by the existing one.
Let us not understand it in the parlance of huge. Huge might have fallen from my mouth, which is not there in the report. Kindly similar, page 44. In view of the above chronological facts and after going through the records and taking into account the position of law and feasibility factor, I will view that there is no legal restriction and legal impediment for grant of on-shop license to the applicant by relaxing distance rule 26 of the as reported by the concerned excise inspector. This is excise commissioner giving on 30th of March. But after the period was over, as the government is saying. Now thereafter, the government is passing an order on 26th of April 22 that re-examine the matter. Kindly similar, directing the collector, annexure 10, to re-examine the matter. Not in my compilation of it. The first judgment I have not that is a page. It starts from page 5. My lord's very recent order. The ground of Article 14. Your Lordship has said if you are considering one application, you cannot reject other application that amounts to discrimination in the same locality. Para 3 and 4. Page 6.
Where is a judgment that says that this period.
That is that page. That is exactly. That is at page 14. Page 14, para 6 and 7. Para 6, 7 and 8. Only distinguishing feature may be
nothing has been.
No issue is there. But then here they themselves are passing order after the period is over. They are directing to inquire, they are directing to resubmit the report. In any view of the matter, all throughout litigation is pending.
Well, in that aspect, there is an order which I have given a copy of which was passed by a bench by this honorable court, where my lord Justice Raman was also part of that bench. My lord may see. Then, my lord, it has been treated as infructuous because the period for which the license had been applied for.
So none of the judgment, both the judgments are not laying down any ratio of.
Can they say in view of their own orders?
But my lord,
can you see the dates when they have passed orders to re-inquire, to re-investigate, to resubmit the report after the period is over? Then what can I do? How do I improve upon the government's expediency, saying that you do it at an early date? You yourself are passing orders to delay it. Kindly see those dates, my lord. When are you passing orders? Kindly see, my lord. My application was there. Inquiry report was there.
There is a provision relating to that particular duration. Under the excise act or the rule. Yes.
Rule 51 is the consent rules
Of
Odisha Excise Rules 2017. This doesn't say of any, but the form. Okay. But the form gives a period. If your lordship sees rules, page 191. Rule like 51 is the concerned rules.
No, it does not talk about the.
What the form says. Form, the concerned relevant form, in terms of rule 51(1), Roman 9 capital B, page 191 of the book. The same, probably your lordship are holding the same book. I have, my books are told.
Having been used
so many times.
And these are scarcely
51
form.
11B.
Yeah, yes, Roman 11B.
Form.
Form Roman 11B, page 191. Application form for grant of license for retail vend of IFL beer. IFL/beer for consumption in the vendor premises for the year. Here they are giving a period and they are taking advantage of this format.
No, where is the timeline which is given?
The consideration of application.
Yes.
But it's there. Rule 51, but it's there.
No, I do not find the time.
I'll show it to you. Yeah. 51, sub-rule 13, my lordship put kindly see. Yes, sub-rule 13. The collector shall, after recording specific opinion, forward the application or other documents and inquire.
What is after obtaining, then within 2 months he has to obtain. That
Everything was there.
That it will lapse. I'm just asking because there are one principles of law which you have to ponder upon, because these two judgments I do not find have really laid down the law.
Right.
There are one line of the decisions which talks about that if a timeline is fixed for doing a particular thing by the authorities, then that timeline is always considered to be directory in nature and not binding. If the timeline is fixed for a person or a litigant to do certain things, then such timeline is mandatory.
Bhavnagar. 2003.
One has to, then will have to, that's a directory or mandatory in that sense.
Right. I don't have any dispute about that.
You'll have to bring those line of judgments that this 2 years period or a 2 months period which is provided there. Because every time it says is a inflexible or a flexible.
Right.
He is citing a judgment which says it become infructuous after 2 months.
Yes.
This says no, you process, it will not. So let there be a straight away on the basis of that. Because this 2 months time is provided to the authority to complete all those exercises.
Correct.
2 months have
Now this cannot be said to be directory that after 2 months it will lapse.
These 2 months time, I'll just show you lots of 2 documents.
And there is no other timeline which is given under Rule 51
No.
that how the application will perish.
So that there is no other timeline except that.
There is no consequences which is also provided.
No consequences provided.
What to do?
But your Lordship will see what they are doing is after that time period is over, that year is.
I understand in your case that they have processed, they continued everything they did.
Yes.
But now this point is taken by him that since it has lapsed, why it has lapsed, I do not know.
But my only humble submission would be, you are passing orders, at least 3 orders after the period is over. Now you are saying that it has lapsed.
No, that cannot be. You have to talk in the sense of the legal procedure. You have to talk in the sense of.
I can't apply logic over here.
Yes.
Kindly see. Kindly see note 14 also. Here also speaks about the time. 14.
What it says.
The excise commissioner shall examine the proposals and transmit the same to the state government with his observation within 2 months from the date of receipt of the collector. That's it. As I said, it's a scheme. What period what is to be done? For the commissioner, it is 2 months. For the government, it is 2 months.
Yes.
And listen, note 1214. And after the period is over, I should not repeat it. Kindly see 13 and 14.
After the period, what has happened?
After the period is over, the government is directing to re-inquire and resubmit the report.
Is there any provision? Does not talk about any
No.
consequences.
Consequence is not there. Is not there. While transmitting such proposals, proposed MGQ of the sub shall be interpreted this. That's all. There is no consequence provided for.
These bring 2 judgments.
I'll get it.
Right.
I should get it.
2003, volume 3, SCC page 433. 2007, volume 8, SCC, page 592.
I'm so grateful. I'll get these 2 judges. I will.
On both principles.
I'll go through this. I do not know in fact. I am not ready.
Both principles.
I'll come back reading. Because
May I request for a copy of the
compilation data. It's there. I have printed one for you.
Next. Item 15.
Yes. But it's a simple case of forfeiture of EMD and imposing penalty.
Now, most complicated. Forfeiture is the most complex issue.
Well, I'll try to make it very simple. Very simple. Your own tender condition says that you can forfeit the EMD of a bidder proportionate to the quantity he has lifted, unlifted, and he has not lifted. Means if he has lifted 50%, 40%, 30%, balance, you will consider it to be abandoned. Then reciprocal amount of EMD you will forfeit. That is your condition. That is the condition, and equally for the penalty also, for the proportionate amount of unlifted quantity. Now, what are you doing is, I was a bidder, I was a successful bidder. You allotted me some quantity of iron ore to be lifted within stipulated period. I lifted almost 50%, 50% I could not lift because of the natural calamity and other things. Now, this repetition is challenging the fresh tender. Now, the fresh tender is already over. So, to that extent, my prayer doesn't survive. But I only request my lords to, because in the meantime, they have taken action of imposing penalty and they have forfeited my entire unit. So I request my lords to mold the relief in terms of their own tender condition. That has to be adjusted to the extent that there is unlimited quantity. That's all. And the power to forfeit the entire EMD is not there with them. That is the only sum and substance of it.
My lord, the provisions of the agreement and contracts, and one abandoned paragraph is there. So the minerals they could not lifted, that will be treated as abandoned goods, and this petitioner has no right over that, and the opposite party has a right over it.
Not disputing that.
My lord. And but
what he's saying is different.
My lord,
He's saying that what he could not do it because of the force majeure clause, he could not do it. Then you cannot forfeit the entire EMD. You have to refund in a pro rata on a proportionate basis. You have to refund. This is what his case is. Though he says that relief in such manner has not been claimed, but by molding the relief, because it is a subsequent act, new lessee has already come, has started. So he is saying that I cannot claim now any right over those minerals. But please return my EMD. How can you forfeit it?
my lord, that is the term, my lord. If the EMD will be turned to as security deposit in the case of a successful bidder. My lord, when he became a successful bidder, it is turned to the security deposit, my lord. And that security deposit cannot be returned, my lord, in this contingent, my lord.
What? Yes, is a force majeure. He had no role to play. It's an act of God. What prevents you not to continue?
I am submitting, my lord. They have given four representations on various grounds, my lord. Somewhere they have told heavy rain, somewhere village unrest, somewhere cancellation of purchase order by the buyer on the ground of degradation of CLO from 60% FE to 57.5% FE. Somewhere degradation of CLO from 60.52% to 58.50%. Several grounds, my lord. Somewhere meager availability of vehicle due to festive season. Somewhere no demand of for CLO. Several grounds they have taken. So force majeure, what they are saying, that is quietly false allegation, and it has been also stipulated in the agreement that on that ground they have not taken the ground of force majeure also. That is also stipulated in the contract, my lord. So keeping in that view, this amount has been imposed, my lord. Entire security deposit has been forfeited, and penalty to the as per the provisions, my lord, if they could not lift at 80%, my lord, 2% plus GST. 2% on the value of the materials plus GST. That has been being calculated. That has been as a penalty that has been imposed, my lord.
I'm not joining this was on the representation point, because that was the ground in my picture. Because I submitted representations without considering my representation, without communicating an order to me, straight to went for a fresh option. And that's what was the ground here to challenge the fresh option. Now that the whole issue is over, new bidder has come up, lifted the materials, I cannot re-agitate here. Of course, that may be a ground for arbitration. I am not taking it now because I also may not go for arbitration. But only thing is page 65, my lords may kindly see. That's the point where 291. In case the bidder do not lift minimum quantity, unit size, unit minus tolerance limit within the specified period, then the amount of security for the incomplete unit will stand for. That's our real tender. Incomplete. I have lifted almost 50%. Balance 50% was left, and that will be treated as abandoned as per their version.
How can you resign from your own?
No, my lord, it is written, my lord. Written. What?
For the purpose of writing or has some value?
No, my lord.
If you have said that if you have not lifted, then you proposed it about.
My lord, I am citing my lord.
So you have got a fresh deposit, security deposit. Be happy with that. Give them back the 50% or 40% or 30%, whatever you determine.
Accordingly,
how much
done, my
the
lord.
amount?
It will be around 5 lakhs.
Accordingly, it has been deducted, my lord. Let me read, my lord, this provision, my lord. Abandoned goods 23, page B, penalty against abandoned goods. If the buyer fails to lift 80% of the total of the allotted quantity, penalty shall be charged at the rate of 2% plus GST plus the sale value of the sale value, excluding all taxes and levies of unlifted quantity calculated from the total quantity allotted. In the case of extension of supply period, sale value to be calculated at the higher price.
This is not the terms and conditions.
No, this is the terms and conditions of the university with regard to penalty 2%, not security deposit.
Security because there.
Yes, this is penalty.
In 23A, my lord, kindly refer to page 77, 23A, my lord, abandoned goods.
Abandoned goods penalty, I don't mind.
That is the last line. The successful bidder shall further be held liable to compensate OMDC for any loss as stipulated in para B below. For all commissions and other charges and losses suffered by the OMDC, the same would be recovered from the security deposit or any other sum due to the successful bidder, including material value. That provision is also there.
This is not there at all. You have not said anywhere that you have sustained any loss, nor you have never given me any notice.
Which one is
reading page 77.
Page 77.
Para 23. Para 23, abandoned goods.
Yes.
For the purpose of penalty, the successful bidder must arrange to complete removal of goods from the site within the date specified in the delivery orders issued by OMDC. In case goods are not removed in full within the specified date, delivery orders for the leftover quantity will be treated as cancelled. The goods so left over will be treated as abandoned goods at the risk of the cost successful bidder. OMDC will have full right over such abandoned goods and will be entitled to dispose of the same in any manner it will deem fit without any reference to successful bidder. The successful bidder will have no claim on goods treated as abandoned goods. Successful bidders shall further be held liable to compensate OMDC for any loss as stipulated in para B below for all commission and other charges and losses suffered by the OMDC. The same would be recovered from the security deposit or any other sum due to the successful bidder, including material value. Penalty against abandoned goods. If the buyer fails to lift 80% of the allotted quantity, penalties shall be charged at the rate of 2% plus GST of the sale value, excluding all taxes and levies of unlifted quantity calculated from the total quantity allotted. In case of extension of supply period, sale value shall be calculated.
There is a forfeiture of the security deposit and the imposition of the penalty are two different distinct concepts. You can impose a penalty on him.
That too for unlimited here, for unlimited quantity penalty.
That is, you can impose, but it does not mean that you can forfeit this security deposit. If forfeiture is provided in clause 6.3, then you'll have to follow this 6.3.
Each unit will be treated as an independent entity. In case the bidder do not reach the minimum quantity within the specified period, then the amount of the stand also. In case the bidder do not reach the minimum quantity within the specified period, then the amount of the SP for the incomplete units will stand forward. Will stand forfeited.
So you have forfeited the security deposit. You yourself is saying that we have forfeited. But then you can forfeit for an incomplete units. So far as the units which he has completed, you have to report.
Well, regarding that, let me obtain instruction.
What is obtain instruction? These are the abandoned goods for penalty. You can impose thereafter a penalty. There is no difficulty. Who prevents you from not imposing the penalty?
They have imposed. They have deducted also.
What more?
Do not leave the minimum quantity within the specified period, then the amount of security deposit for the incomplete units will stand forfeited.
This is what is required. But incomplete part. But what he has completed, can you?
Kindly, one time to take off instruction, my lord. That the incomplete items, it will be to that ratio, it will be forfeited as total.
This is what it appears.
Because, my lord,
For incomplete units. This for incomplete units means that.
My lord, while the EMT is being fixed, which is subsequently converted to security deposit, my lord, EMD is fixed on the tender amount, my lord. So can it be now segregated for complete and incomplete?
You delete this clause, sir. You delete the clause. Why you are incorporating those clauses? You cannot say.
One time, my lord.
If you have. When it talks about what is the meaning, then the amount of SD, amount of SD is related for the incomplete units. Then you have to segregate. Otherwise, it would have been then the SD, the security deposit shall stand forfeited.
That's all.
Straight away language. But you have said no, sir.
Okay. Kindly give me 200 time.
What? And look for this 47 rupees 5 lakh. His engagement has started.
I was
for another day.
The initial
you
step,
will consider what will happen to
it's only
the client, the other side.
I was engaged for the initial, I don't know. Now I'm continuing with this.
For 5 lakhs only. How many years already gone? Do not know. a small amount, sir. Why are you fighting?
Only
You
one.
have got the security deposit, full security deposit from the erstwhile bidder.
But we put money also.
You are secured in that.
One week time. Only 1 week time for invoice. Obtain the instruction.
No difficulty. Take care of his memo. I mean,
What are they?
I got exceeded, I do not.
yes, take care of that.
I do not understand very
Offline or off job or on job.
This is CS, country spirit, country liquor.
Mahua.
No, that is OS. This is out of molasses. CL is prepared out of molasses.
Molasses.
Like here, due to short clipping of the MGQ, the shop was closed, taking recourse of Rule 35. Rule 35 D1 says, if any license is area of the state, the shop will be, no license will be renewed. Then they raised the demand 2.26 crore against 92,000 some odd LPL. Then immediately I honored, satisfied the demand notice, deposited 50%. 1 crore 13 lakhs I deposited. Then I approached this one. Then the lordship directed, one of the coordinate bench directed to pay next 20%. I paid entire amount. Now the only question, after payment of entire excise duty they have levied, I am now entitled for lifting of the corresponding MGQ. This matter already, the lordship has already had this matter at length. Then on 17th December, this was adjourned at the instance of state government. This is the only issue. Lordship knows 29 is the charging section. Says on the sold item, already excise duty is level.
You were short notes. Section
29.
Yes.
It's excise duty and countervailing duty. An excise duty or countervailing duty of such amount as the government may, by notification specified from time to time, shall be levied on all liquor permitted to be imported, exported, manufactured, issued from manufacturer to institution, or sold. So I am on sold man. Because
Let's do this. This is what is this?
29.
Yes.
It clearly says the excise duty is leviable on the item which has been sold. But here, my lord, I have not, I totally not lifted. In honoring my lord, generously I have paid the entire excise duty raised by the state government. That is 2.26 crore. But they had taken the recourse of Rule 35, close my shop.
No, it does not permitted to be imported, exported, manufactured.
And
you are a manufacturer.
Not sold. And the licensee to bring all the products from the warehouse of the state government. Orissa State Beverage Corporation.
So are you a retailer or
I'm a retailer.
Issued from anywhere, then sold?
Sold. I have not lifted at all.
Yeah.
But they raised the demand. I honored the same. Now only my lord have paid the entire demand they have raised. But till that, they have not issued the corresponding MGQ against that excise duty I have already paid. That comes to near to 92,000 liters.
Why are you not doing it? If you have received the excise duty.
My lord says, my lords may kindly see page 13 of our counter. In paragraph 2, when we have placed reliance on subsection 9 of Rule 34, that it says that if there's a shortfall in withdrawing
Which one you are relying?
my counter methods and excise rules. 2000
Act or a rules
rules.
Rule 34,
Rule
madam.
34.
of 2017.
17, madam.
Yes, ma'am.
Rule 34, what it says?
Rule 34, subclause 9. Sorry, ma'am, subclause 8. In case of default, if I may read this. In case of default, the excise duty on the deficit quantity of annual MGQ without prejudice to any other mode of recovery shall be collected at the end of the year with a fine at the rate of 10% on the deficit amount. And on failure to such fine, the same shall be recovered as arrear of land revenue under provision of Odisha Public Demand Recovery Act. Well, if this, as per under this rule, the demand notice was issued. Furthermore, this rule does not say that just because the demand notice, the dues have been paid, the arrear dues, the corresponding amount which was not lifted, they could lift it in the subsequent year. This section is absolutely silent on that. And also, my lords, as a even in general practice, my lords, once the demand, once the arrear dues are cleared or paid for and the demand is paid, then there is no lifting allowed for subsequent years, my lords.
The question is, yes, there is a distinction between a fine to be imposed, then the excise duty to be collected on the differential amount or under the MG. If you talk about the clause 8, the clause 8 says that in case of a default means in lifting the permitted quantity, the excise duty, the word is excise duty on the deficit.
Yes.
Quantity of amount MGQ without prejudice to the any other mode of a recovery shall be collected. So what you are collecting is the excise duty on the deficit quantity of the minimum guaranteed quantity.
Yes, ma'am.
You are collecting an excise duty.
Yes, ma'am.
At the end of the year, what is the additional which they have to pay is with the fine 10%. At the rate of 10% on the deficit amount. So they are not only obliged to pay the excise duty leviable on that quantity, but an additional fine at the rate of 10% will be imposed.
If there's a short.
So if they have paid the excise duty is paid on what? Lifting of the materials.
Yes.
And then the excise duty is paid. So why they will not be permitted as a equitable principles to lift those?
Sir, may I rely on page 14 of our counter? Let's speak paragraph 2, if I may read. That the MGQ fixed for each retail excise license represents the minimum quantity of liquor which the licensee guarantees to lift during the currency of that year, thereby assuring a minimum level of revenue to state government. The MGQ, by its very nature, is an annual and non-transferable fiscal obligation, not a stock entitlement capable of being carried forward or adjusted in subsequent periods.
Where from you get it?
Yes, madam.
Please look at the policy. But the policy I understand, if correctly,